Good morning, everyone. Thank you all so much for coming this morning to our breakfast series. Today we've got three speakers, Ian Hull, Natalia Angelini, and Paul Trudell. I think we've got interesting topics. We always try to think of something topical and of interest, especially to the estate planning side. Before we start, I just want to briefly introduce here today members of our office who help us do what we do and make us strive to be the best we can do at estate litigation and assisting the practice of estate law. Heather McGinnis and Frykowski are here. They're both estate clerks. And Elizabeth Sonderskov as well. Christine Mercer is here. Noah Weisberg and Stuart Clark are our articling students and both doing a great job. Nadia Harasimowicz. Maura Vishu just came in. Hi, Maura. Susanna Popovic-Montag, one of my partners, and of course our speakers here this morning. So the first topic that we've got is Paul Trudell, and Paul's going to speak about professional conduct issues for estate solicitors.
Good morning and thank you. And as David stated, I'm going to speak about professional conduct issues, and in particular the rules of professional conduct of the Law Society of Upper Canada and how they impact on our practice as estate lawyers. And I want to go through some of the rules and some of the applicable rules that we come across daily. And I don't want us to see the rules of professional conduct as being a nuisance or something that is an impediment to our practice, but rather a guide to excellent practice and a guide to building and maintaining a proud profession. We know from the rules, and we know in general, that as a member of a privileged profession, we're held out as being knowledgeable, skilled, and capable in the practice of law, and that a client is entitled to assume that the lawyer has the ability and capacity to complete the skills, to complete the assignments that were given. Where we fail to do that, we not only do the client a disservice, but we bring discredit to the profession, and also, as the rules indicate, we may also bring the administration of justice into disrepute. There's a very high burden and onus on us to meet the rules, and I think it's important to review the rules and ensure that we're able to deliver the services that we are entrusted to deliver. The first rule that I want to turn to is Rule 2, one of the first rules, one of the most important rules, in its relationship with clients. And Rule 2.04 sub 2 simply states that a lawyer shall perform any legal services undertaken on a client's behalf to the standard of a competent lawyer. That sounds easy enough. What is meant by competent lawyer? Well, that's set out in some detail in the rules, and I think it's instructive and informative to go through what is meant by a competent lawyer, what the elements of competency are, and what we need to bring to the table. A competent lawyer is a lawyer who has and applies the relevant skills, attributes, and values in a manner appropriate to each matter undertaken on behalf of a client. So we have to have the appropriate skills and abilities and values and also apply those in all circumstances. The rule then breaks down what is meant by having the relevant skills, attributes, and values. And I'm going to go through those in a little bit of detail because I think it helps inform us as to what we should be striving for. Sub A requires that we know general legal principles and procedure and the substantive law and procedure for areas of law in which the lawyer practices. And there's four elements there that should be taken away. The first is that we have to have a general knowledge of legal principles and a general knowledge of the legal procedures. More importantly, we have to have knowledge of the substantive law and procedure for the areas in which we practice. This requires particular information or knowledge and skills and ability with respect to estate planning. And that's why we come to seminars today, to learn about joint property, disinheriting a client. We need to have that specific knowledge if we're going to carry on the practice of estate planning and all of the issues that arise. And we need to have specific knowledge of, for example, issues with tax law that impact on estate planning, family law obligations, ODSP requirements, the appropriateness of mutual wills, multiple wills, mutual wills, mirror wills, beneficiary designations, and how they impact on an estate plan. And the list goes on, and that's another reason why it's important to come to events like this and other continuing professional development, so that we have those relevant skills that we're expected to have when estate planning. The rule goes on to state that we're supposed to have skills to investigate facts, identify issues, ascertain client objectives, consider possible options, and develop and advise a client on an appropriate course of action. The important part for the estate planner in this rule is to ask the important questions and the relevant questions. It's through probing that we're able to determine what the facts are and identify what issues may come up in determining what an appropriate plan is. We can determine client objectives and issues that may impact on those objectives. And in order to ensure that we ask all of the right questions and make the proper inquiries, I think it's essential that we develop a good will planning checklist and use that to ensure that we don't miss any of the important probing questions that we need to ask. Further, through those probing questions, we can determine what the intentions of the client are, and also impediments to those intentions, obligations that they may have that may impact on what it is that they want to do. The next part of Rule 204 sub 2 requires that we implement, as each manner requires, the chosen course of action through the application of appropriate skills, including, and there's a number of skills that we need to apply in implementing the plan, such as legal research, analysis, application of the law to the relevant facts, writing and drafting, negotiation, alternate dispute resolution, advocacy, and potential problem solving. And I think that this rule deals with getting from A to B. Once we've asked the right questions, found out what the facts are, what the intent is, what issues will impact on the implementation of that plan, we then need to apply that list of skills in order to figure out and determine how to do it, and apply the legal skills to get that done. One of the important skills a lawyer has to have, as set out in the rules, is communicating at all stages of a matter in a timely and an effective manner, and the communication must be appropriate to the age and the abilities of the client. We know from Law Society publications that failure to communicate is a leading cause of complaints against lawyers, and timely and effective communication can assist in avoiding many of these complaints. Further, as the rule states, the communication must be appropriate to the abilities and skills of the client. As estate practitioners, we often deal with elderly clients or challenged clients or elderly and challenged clients, and our communication must be aimed at properly addressing the needs of the client. The rule requires that we perform all functions conscientiously, diligently, and in a timely and cost-effective manner. In the context of timeliness of services, this can take on a special importance in estate planning. Many claims have arisen by beneficiaries who have been disappointed as a result of a will not being drafted in a timely manner. And there's a long line of cases that goes back to White and Jones, where disappointed beneficiaries have brought claims, and in many cases have been successful, where they were intended to be beneficiaries, but they weren't beneficiaries of the estate because of a failure to draft the will in a timely manner. And in White and Jones, the testator was, he disowned his daughters, probably as a result of reviewing Ian and Susanna's paper from later today on how to disinherit your children. He later, though, had a change of heart, and he reconciled with them, and he went to his lawyer to put them back into the will. He gave his lawyer instructions to do that, and make a bequest to each of his two daughters. Unfortunately, due to a vacation and the file simply appearing to languish, that will wasn't prepared for a period of 2 months, and ultimately an appointment was set up with the client. As fate would have it, the client passed away 3 days before that meeting. The daughters brought a claim against the lawyer as disappointed beneficiaries, and they were successful, and the lawyer was found liable to them for the bequest that didn't materialize. How long is too long then in the preparation of a will? Well, that was considered in an Ontario case of Rosenberg Estate from 2001, and there the court heard expert evidence as to how long is too long with respect to preparing a will. And the court heard expert evidence that there is no magic time period, no 2-week period, 2-day period, and there's a flexible approach taken with respect to that, and it depends, as always, on the facts and circumstances of the case. However, the court did hear expert evidence as to the factors which are to be considered in determining how long is too long to prepare a will. There's 6 factors that the expert evidence revealed. One is the terms of the retainer. What is your agreement with the client? Did you say you would do the will in 2 weeks? Did you say you'd do it in 2 days? The terms of the retainer are very important. Whether any delay was a result of the action of the client. Was the client to provide you with information that he or she just didn't do, because that would impact on the timeliness and the time frame in which to prepare the will. Another factor is the importance of the will. Is this a first will or a will after a marriage or a divorce, or whether it was simply a codicil that changed the beneficiary with respect to a car or appointing an estate trustee. The complexity of the estate plan is another factor. Obviously, the more complex the estate, the more time may be required to put the plan into effect. Perhaps one of the most important factors is the circumstances that might indicate a risk of death or a risk that the testator may lose capacity. And again, this may come out from your probing questions and your fact-finding. Is there any information that you were able to determine, or did you ask whether there's any issue that might mean that the will needs to be prepared in a more timely manner? And finally, whether there's been a reasonable ordering of the lawyer's priorities. Whether the client has a right to expect that the will is going to be prepared tomorrow as opposed to a week or 2 from now. Where there is a will that needs to be prepared and the lawyer is aware of that, so the client may be advised to prepare at least a rough temporary will in his or her own handwriting, setting out the basic intentions of the will, so that if something does go afoul and the person isn't able to execute the will, or the will is not able to be prepared for a certain period of time, there is something in writing that may help the circumstances, help the situation. Another piece of advice we get from the texts, and one of the best articles is Rodney Hall's article, "A Current File with an Unsigned Will, a Loose Cannon in the Solicitor's Office," and there's a site for that in my paper, is to ensure that there's appropriate follow-up with the client. When you send the draft will out, don't let it just sit out there unsigned. Make sure you follow up with the client to ensure that they are aware that it's unsigned and that there's something more that needs to be done. Returning to the rules require that we apply intellectual capacity, judgment, and deliberation in all functions, comply in the letter and spirit with the rules of conduct, this is an important one, recognize limitations on one's ability to handle a matter or some aspect of it, and take steps accordingly to ensure that the client is appropriately served. One of the important decisions we need to make when we're in the process of being retained is determine whether we can undertake the retainer. If it's something that's beyond our capacity, we should let the client know at the outset and make sure that they get proper representation. If there's a matter or an aspect of the file that we are not feeling comfortable with, we should tell the client of this and ensure that they get appropriate advice. For example, if there's a complex tax issue, it's important to ensure that the client is advised that this is not something that's in our area of expertise, and ensure that they get proper representation. The rules require that we manage one's practice effectively. It doesn't go into any detail on that. It requires that we pursue appropriate professional development to maintain and enhance our legal knowledge and skills. That's now been codified, as we know, by Law Society bylaws, that we require that we get our 12 hours of CPD, including 3 hours of professionalism. And that's a good reason why for all of you to be here today, and don't forget to log your time with the Law Society after today. And finally, the rules require, this rule on dealing with the client, that we adapt to changing professional requirements, standards, techniques, and practices. The law is evolving and we must keep up with it. Another good reason to be here today. The next rule that I'm going to turn to and discuss is Rule 2.02 sub 6, which is dealing with a client under a disability. As indicated previously, we must communicate with a client in accordance with their abilities and ensure that they understand the advice that we're giving. Rule 2.206 says that where the client's abilities to make decisions is impaired by reason of a disability, such as minority, mental disability, or for some other reason, we must, as far as reasonably possible, maintain a normal client relationship with the client. So we must gear the delivery of our services to our clients to ensure that they're properly served. On top of this now is another layer. It's the Accessibility for Ontarians with Disabilities Act 2005. Provisions of that came into effect on January 1, 2012, and it requires that every provider of a good or service with at least one employee, so that means you, must establish policies, practices, and procedures governing the provision of services to people with disabilities, and also provide training that meets with specified requirements. The Law Society has been helpful in preparing a guide for lawyers as to what's required in order to ensure that we comply with the provisions of that Act, and they also include in their materials a model policy that we should all be considering and adopting and revising as may be required, and I put a cite for that guide in my paper. The next rule that I'd like to turn to that has particular impact to estate solicitors is Rule 2.03, which deals with confidentiality. A lawyer must at all times hold in strict confidence all information concerning the business and affairs of the client acquired in the course of the professional relationship, and shall not divulge such information unless expressly or impliedly authorized by the client or required by law to do so. So the lawyer's obligation to the testator is to hold all information that we receive in confidence. However, there's an exception with respect to the disclosure of the will. As the commentary in the rule provides, or in certain cases it's implied that we're authorized to release that information. And this was considered in a recent decision of Mr. Justice Brown, the Hope and Martin decision of 2011, where he gives reasons to the effect that where a deceased makes a will, it follows that the will is intended to have some effect following death, and therefore the client has authorized us to release that will. However, the proviso is that it must be released to the appropriate person so that the intentions of the will can be fulfilled. The Hope and Martin case addressed who is the appropriate person to release the will to. In that case, the lawyer held a will that appointed two estate trustees. Both had renounced. There were a number of beneficiaries, and one of the beneficiaries was going to apply for a certificate of appointment. The lawyer felt that he didn't have the authority to release the will to that beneficiary. However, there was consent of all of the other beneficiaries. Mr. Justice Brown felt that in those circumstances where there was no contestation of the will, the lawyer was authorized to release the will and that an order wasn't required. However, there's no authorization, or that authorization may not be present, and there may be no appropriate person to release the will to where the will is being challenged. And in that case, the lawyer should require that a court order be obtained. Finally, on the point of confidentiality, Rule 2.03 sub 6 deals with literary works. A lawyer who engages in literary works, such as writing an autobiography or a memoir must retain or not disclose all confidential information without the consent of the client. And I think that's probably the one reason why the Ian Hull story hasn't yet made it to the big screen. He still hasn't tied up all of the right consents. The next rule I want to turn to that applies in particular to estate practitioners is the avoidance of conflicts of interest. The avoidance of a conflict of interest. Conflict of interest is defined in the rules as being an interest that would likely affect adversely a lawyer's judgment on behalf of or loyalty to a client or prospective client, or where the lawyer might be prompted to prefer the interests of a client or prospective client. This is particularly an issue where we're retained by spouses to prepare wills. And there's been a number of papers prepared on the issue of joint retainers, including a paper by Susanna Popovic-Montag and Ian Hull that I've referred to in my article. Where there is a joint retainer, the rules require that the lawyer confirm and advise the clients that he's been retained to act on behalf of both clients, that no information that he receives from any one client can be held from the other, and that if a conflict develops, he must advise them that he can't act for both of them and may have to withdraw completely. This is a particular concern where there are joint wills prepared by spouses, and there's commentary in the rules that deal specifically with that. And the commentary provides that where a lawyer is retained by spouses, they should be advised to obtain independent legal advice with respect to the joint retainer. And that's particularly the case where one of the clients is less sophisticated or more vulnerable than the other. The lawyer should then advise both clients that he is jointly retained and follow the requirements that I've addressed before, such as advising that he's being jointly retained, that there is no confidentiality of information as between the two clients, and that he may not be able to act for both. If the spouse is returned to that lawyer to make a new will, that's considered a new retainer, and it's to be held in confidence. The lawyer is not to advise the spouse of that, and he has a duty to decline the retainer unless there's consent. I'm told I have 1 minute left. I'd just like to talk about one more point on the issue of joint retainers. What happens where we have a client of a long-standing client, and they come to us and they want to prepare a will for themselves and their new spouse? In that case, there's a rule that specifically applies to dealings where a lawyer has a continuing relationship or a long-standing relationship with one client. And before he accepts retainer with respect to that long-standing client and the spouse or the new client, he must advise the new client, of that long-standing relationship and recommend that the client obtain independent legal advice. I want to thank you for giving me the opportunity to speak to you today, and I appreciated the chance to go through the rules. I feel that I've benefited from reviewing the rules, and I think that we all could benefit by a review of the rules of professional conduct from time to time, and that reviewing them gives us a good reminder of the standards that we're to achieve when practicing law. Thank you very much.
Thank you, Paul. It was very helpful, I think, for us also to see how the rules dovetail with some of these legal authorities that have recently come out, and just to give consideration to the duty of care. So thanks for that, Paul. Our next speaker is Natalia Angelini, and Natalia is going to speak about issues relating to the joint ownership of property, which, of course, is of interest to all of us. Thank you.
Thank you, David. Good morning, everyone. Well, I don't think I can begin this talk without addressing PACOR, which was a pivotal decision, and I'm sure most or all of you are aware of it, so I'll be brief with respect to the facts. In essence, this was a case where a father had joint accounts with his daughter, and he passed away, and his daughter's husband was a beneficiary of his estate. So the daughter and her husband were having marital trouble and were in litigation, and the husband wanted the joint account funds to result to the estate so he could, I guess, take a piece of the funds. And the daughter argued that, well, no, these funds are a gift, and they should be completely given to me. So the decision was very comprehensive, and it looked at the presumption of advancement and presumption of resulting trust, and the court's finding was that the presumption of advancement did apply, and the daughter received all of the funds. And in looking at the presumption of advancement, just to refresh, I guess, everyone's memory, that's where you've got title to property in one person's name. It's transferred for no consideration, and the presumption is that it was intended to be a gift to that person. So if someone is challenging that gift, then the onus is on the challenger to prove that it was not, in fact, intended to be a gift. Now, PACOR also looked at the standard of the burden, and it is a rebuttable standard, and it's not a beyond a reasonable doubt standard. It's on the balance of probabilities. So it can be met if enough evidence is put in to meet that test. But the more, I guess, common presumption that's applied is the presumption of resulting trust. And that's where you've got, again, a transfer for no consideration, and the presumption is that the transferor intended to retain the beneficial ownership. So the burden of proving that that it was a gift is on the intended recipient of the funds or the property. And PCOR really modernizes the law and fine-tunes the law. It's sort of interesting when you look historically at how these presumptions develop their way through the courts. And it didn't comment on the presumption in respect of spouses. However, with respect to the presumption dealing with parents and children, it narrowed the law in one way and expanded it in another. So with respect to, if we look at spouses, the presumption of advancement really began in the 18th century, and it reflected the course of affairs in families where wives were typically dependent on their husbands. Husbands were seen to be giving gift to their wives and gifts to their children, and to have that obligation of support. And I think it reflects the fact that spouses were so close that it's not right to treat them as strangers by not applying the presumption of advancement. But that said, over the years in common law Canada, the presumption of advancement really diminished significantly. And in 1975, Ontario legislation abolished it, but it's currently revived to some extent in that the Family Law Act, Section 14, says that the rule of law applying a presumption of a resulting trust applies in questions of the ownership of property between spouses, except that if the property is held in joint names, then that's proof that they intended to own it as joint tenants. And if they've got accounts that are held in joint accounts, then they're deemed to be held as joint tenants. So even though the FLA states that the presumption of resulting trust applies, in essence, with respect to joint property between spouses, we've still got the presumption of advancement that is alive. And I guess for us lawyers, it makes it simpler when we've got clients who are spouses that want to transfer property or deal with their estate planning, and they've got joint property. It's less of an onus on us to be careful as to how we advise them. But that's not so with respect to others. So I'll move on to parents and children. And PCOR, I think it was a good decision in that with respect to mothers and their children, it really reflected modern day times, which is women today are working, they're financially, they got financial resources, and they've got a statutory obligation to support their kids under the FLA. And so women are seen to having the means and the obligation to care for their kids. So they're no less likely to intend joint ownership to be a gift to their children as fathers do. So the presumption of advancement was expanded to apply to gifts joint ownership between mothers and their children. And then with respect to adult children, the decision I think is a bit more controversial, because we have, again, looking at the modern day where we've got our parents, our elderly parents, in order to help them facilitate management of their financial affairs, they, for convenience sake, often have their children added on as joint owners to accounts, added on as joint owners to their property. They're given their powers of attorney. So the presumption really is one of resulting trust, that parents aren't intending this to be a gift to their adult children. It's simply to help them manage their affairs. And interestingly, the court points out, well, once kids become adults, the burden could shift, because parents can assert claims under the Family Law Act for support from their children. If need exists and the ability to pay exists, then kids can be in that position. So I guess it's not really, it's sensical. It makes sense to think that the presumption of resulting trust would apply rather than one of advancement. But where I think the more controversial point the court makes is in respect of adult dependent children. And I think it's a much trickier situation. to figure out, or for the court to figure out, what amounts to dependency. And I mean, in a way, perhaps there was a strong dissent in this decision, and perhaps the majority, I don't want to say took the easy way out, but it was a bit easier to say, look, it's too uncertain. What creates dependency can cause unpredictability in almost every case, so we're just going to say, no, it does not apply to adult-dependent children at all. That said, they did note that if the dependent child puts evidence forward that shows a strong degree of dependency, then that obviously will go a long way to rebutting the presumption. So, and again, the dissent was quite strong in this regard, but I mean, this is the law as it stands now. And looking at the cases since Pecora, there are a few of them in my paper. I'm only just going to touch on a couple, but really we haven't seen, I haven't really seen any surprises. It's been 4 years now. The cases seem to be applying Pecora and not really straying at all from its directive. And an interesting one, it's actually not an estate case, but it's interesting because it's a Simcoff decision. It's in my paper, and it's a case where a mother owned a property and she put it into joint ownership with her and her son, but then later they had a falling out, and she brought an application seeking a declaration that she was the sole owner by way of resulting trust. So it's interesting because this is one case where we've got a live person who's putting that evidence forward, and the court still found no. You understood, it relied heavily on the evidence that around the time of the transfer that she understood what it meant to register that property in joint names. And so the court found that she was not successful. And another case of Harrington, that's an Ontario decision, Harrington and Harrington. This is a case, it's more of a classic case, I suppose, where you've got father had joint accounts with his son. He also had named his son as power of attorney for property. And the son had, father passed away, son had marital problems, and the wife wanted not just the principal amount, these funds were invested, so not just the principal amount, but also the income to fall into her husband's property and not the estate. So the son was successful in convincing the court that, well, with respect to the principal amount, the presumption of resulting trust applied, which in this case was in the son's favor. But the presumption of advancement, the court found, applied with respect to the growth on those funds. And the court looked at, it seemed to place weight on the fact that the son was using those funds for not only his benefit, but for his wife's benefit at the time. The funds were in an account in his name. So the use of the funds definitely played a role in the court's decision. And that sort of brings me to, and how it affects us, is what evidence is there needed to rebut the presumption? And that's going to tie into how we advise our clients at the time that these transactions are contemplated. So the type of evidence that is the most important is evidence at the time the transfer was made, and evidence of the transferor specifically. So through Pecora and looking at the other cases, these are some of the factors I've pulled from them. And so what we look at to just demonstrate the evidence of the transferor is, or what the court looks at, is the wording of the document, how the property is used, like in Harrington, the tax treatment of the property, the degree of friendship or closeness between the transferor and transferee. And again, that may come into play where you've got an adult dependent trying to rebut the presumption, for instance. The wording of the will, the testator's will, whether a power of attorney was granted, because that may show that the testator appreciated the distinction between granting a power and gifting a right of survivorship. And with respect to evidence post-transfer, there the court's being careful and saying, it's not excluded, but that evidence must relate to the intention at the time of the transfer. And judges are going to be careful in giving it weight and looking at and guarding against evidence that is self-serving just to show that the testator had changed their mind after the fact, because as we saw in Simcoff, that didn't get her very far. So, turning to how this impacts us and how we advise our clients, I think there's some helpful points that I sort of have, and maybe you've got others. But one of them is to encourage our clients to have documentation prepared that establishes the donative intent of the transferor. So if they've got joint accounts that have the right of survivorship, the client should be advised, or they should make sure that there's express reference to the beneficial entitlement somewhere in that documentation to those accounts. Taking instructions and recording the testator's intention is now key. We can't just sit back and say, oh yeah, it's a joint asset, don't worry about it, it falls outside of the estate. Documenting intention is key, and I think we've seen documenting everything we're doing seems to be critical in order to protect ourselves, and also to, I guess, assist the court down the road when litigation arises. Another thing that was interesting is some of the cases where people were unsuccessful in rebutting the presumption of resulting trust, like in the Masden decision, was where the transferee didn't even know that the transfer had taken place. So maybe another suggestion to our clients is notify the transferee in writing or in some way that the transfer has been made. And perhaps probe further with them. What's your intention in doing this? What's your intention in creating this document? What's your intention should you die first? And documenting those kinds of questions. And some other tips might be, because joint ownership is one way, but it's got its own pitfalls, which I may have time to get to, but to other ways may be suggesting that a revocable trust be prepared. And that's where you've got the transferor is the sole income and capital beneficiary during lifetime, with distribution to the next generation on his or her death. Another option might be a declaratory trust, where you have the intended beneficiary of the property signing a declaration at the time the property is being transferred, that essentially says this transfer is solely being done for estate planning purposes, and even though I'm the registered owner, my interest is held in trust for the benefit of the other owner until their death. Now, I haven't seen a court consider this scenario, but it might be something we can try, and or maybe people are already doing, and I guess you may or may not have success with it, but I guess it's better than doing nothing. And then one other thing I was thinking about is, what happens if following death you do have a decision where the court finds, well, no, the resulting trust applies, that presumption applies, so the property is reverting back to the estate. Does that now mean that your probate tax savings is now undermined? And it's a possibility. I don't know the answer, but one way to perhaps guard against that is perhaps have a secondary will done, which I know a lot of lawyers do use that tool, and have a clause in there that states that assets that revert back to the estate by way of resulting trust are to be distributed according to the terms of the secondary will. So perhaps that way you can avoid having the estate subject to probate fees in respect of that asset. I think I might be out of time. Just briefly, given the pitfalls of joint ownership, such as an owner not being able to recover property or mortgage or sell it without the consent of a spouse or a jointly a child that you own property with, given that it can be exposed to claims by others if you've got marital problems or financial problems, or your child does that you own the property with, then it is a good idea to think about these pitfalls and other pitfalls that are mentioned in my paper when giving advice. So thank you. I think that's all the time I have.
Thank you, Natalia. I thought that was a really good summary of the situation, and certainly as litigators, the biggest problem with these cases is always evidence. And so I think I commend that part of Natalia's paper to everyone. Last topic is Ian Hull speaking on disinheritance. How do you effectively do it?
Well, thanks very much, David, and welcome to everyone to our first seminar of the year. And I was talking with Arthur Angus earlier, the bane of the lawyer's existence is that we start January 1 at 0, both from our dockets and our CLE points. So we are now building our CLE points rapidly, and I know everyone here, of course, is docketed like mad in the first half of this month, so the numbers don't matter anymore. I just want to talk, before I start, I wanted to talk a little bit about one. During the break, I had a chance to read a couple of books that I thought were really interesting. There's one book I went through and read, it's called With a Stroke of a Pen, Claim Your Life, and it's by Jane Blaufus. It's a book, you have to buy it online, but I just wanted to spend a couple minutes on it because I thought it was an interesting resource, because I'm going to talk a little bit about how to disinherit and some of the issues there. But this is a book written by an insurance advisor who personally, her husband died in a car accident. They were living this perfect life in Winnipeg, and one daughter, husband died of a car accident, and she chronicles the steps that she had to take and some of the sort of to-dos and the watching points for families to consider. Now, her story is it's fantastic. It's a great story told, but it's a little more dramatic because it was an accident. Nobody was ready for it. But what it did was it highlighted some of the issues that she sort of thought that many of our clients should be thinking about as we gradually progress to the moment of death, as opposed to the urgent progression. And you know, she starts off the book talking about some of the courageous questions to ask ourselves. Well, as counsel, as lawyers, we're obligated, and part of our job is to ask those tough questions when we're taking instructions and we're getting an idea of the plan, and we start to especially see an idea of a plan that's going to include some element of disinheritance. She talks about some of the information we have, and we should have interesting chapter just on funeral and prearrangements and all of those sorts of things from her perspective. And it's a really, I just thought it's a handy book and an interesting book. I'm sure I forget what I paid online, but it's an easy read, but it's also a really handy book to clients. You may want to encourage them to take a look at. She's written it very effectively, sort of takeaways for each chapter. She's got a little summary of takeaways from the chapter, so you can get through the book pretty quickly. But I'm always looking for resources that I can point my clients to really get to the nub of some of the, some of the urgencies, but some of the issues that they're going to want to deal with in the context of the estate planning that don't tie directly to whether or not we're going to put the RRSP registered, or directly to the designated to the daughter, or do we, how are we going to deal with some of these? What are clinical decisions that we have to make? This sort of puts a human element to it, and one of these sort of takeaways that, if we can, when we're taking instructions, we want to help our clients along the process of not just estate planning from the technical standpoint, but adding that extra layer of value. So I just thought I'd throw that little nugget out. We put it on our website. We have a books site on our webpage, and anytime any of us read an interesting book, we throw the link on there, and there's a lot of them there. We've been going through over the years, but I'm going to throw that one on the page as well. So that ties into my talk and where I want to go with a little bit on this disinheritance, because the interesting model is that our business model, as we're litigators, is our business model is disinheritance is good. So we want this to be encouraged. But your business model is inheritance is good, and we want to, and the solicitor's side, we don't want to have this encouraged. So knowing this business model exists, it really is fascinating for me to sort of sit back and look from the contentious side, what are some of the elements of disinheritance that we should be keeping top of mind? And I start this thinking by looking at sort of the data and the theory behind succession planning. Because, it's not magic, but the data, I base some of this data just through my own research and so on. But there's a great study done out of the UK, and it was in mid 2006. There's an article in Step Journal in 2006 that dealt with it. But there's been tons of data since then to support it. But the idea is that when you get your client, they come in to see you. One of the roles of our advisor roles is to assess the extent and the type of pressures that our client is actually feeling. And disinheritance, elements of disinheritance, is a fundamental pressure. If I'm going to disinherit any of my surrounding circle around me, that's a tremendous pressure on the client at every level, whether it's at the moment of making the decision or they've been living it. They've been tortured by, in their mind, their son or daughter, and they want to cut them out. And that part of it is an important stress that we are going to be assessing when we come in and they come in to take our instructions. Then exploring the different attitudes and generational issues and identifying the trends, it seems to me to be a big issue, because the struggle with the main tension is this. Clients are coming in and they're saying, look, we want to maintain the integrity of our estate, that asset to pass down to the generation. But they're also struggling with what's perceived to be a fair but maybe not equal distribution of that asset to their children. And so the data shows that, of course, now the oldest in line no longer gets the farm. That whole tradition is gone. The priority for business managers is they want to get the child in the business, pass on the business elements of their estate to the one that seems interested and effective and wants to take on the role. The difference between, of course, succession to manage and succession to own is a struggle that our clients are feeling. And these are the sorts of tensions that they're feeling when they're coming into what may not amount to, in their mind, disinheriting, i.e. give Jane the operating business and give Bill some money, as opposed to, in their mind, they might be just sort of saying, well, that's what I should be doing because Jane is in the business and she's the operationally. And then when they die, they come to see us and they perceive it, the children perceive it as though they have been disinherited. And Billy's sitting there saying, well, I should have been able to, and for a bunch of reasons that we never discussed. So this, combined with this growing trend of entrepreneurial spirit and tremendously high wages and remuneration for people, has created this generation of people that it's easier to individually create some substantial wealth. And we see it more and more every day. The old money, the British sort of tradition where you had tracts of land and you passed those tracts of land for 600 years down to different generations, there's a real paternal attitude to the inheritance model. And that's fine, and it still exists today, notwithstanding, it doesn't matter what your asset is, even people who've created the assets more recently. But the newer money approach and the client's approach is that they don't rely on their parents for the inheritance. I mean, many of them, when they come to see us, have amassed wealth that is beyond what their parents amassed. Their concern is, in some respects, giving too much money to their kids, who will be disincentivized by the events, and then they're generally going to have to figure out an estate plan that will maintain this idea that their kids must work hard like they did to create the wealth. So these kinds of tensions are there, and as advisors, we're sitting there trying to manage these. We're in a more complex environment, and the truth is, at the end of the day, whatever role we're playing at any level in the process or any stage of the process of estate planning, we're getting dragged in for more piecemeal assignments, lawyers especially, because we're getting told, do the will, stay out of the life insurance, or stay out of this element of my life, stay out of that element, I just want to do the will. Same problem for the financial advisors. Their role is make sure the joint account is set up, the investment account rolls over to Betty on my death, don't ask any questions, and as Natalia is identifying, that kind of piecemeal planning is problematic. And the tremendous pressures of our expectations on all of us are that the loyalty of the client isn't rock solid maybe as it used to be. So knowing that data, knowing that that's the sort of, and that's a very generalized summary of the pressures that are being felt on our clients, what does it mean as a lawyer to get involved in this? And I talk about in my paper some interesting and innovative claims, and I won't have time to get too much through it today, but in terms of some tortious interference with inheritance rights that are developing in the U.S., where Anna Nicole Smith made a great charge at the son of her $90 billion husband, who got in the way of her inheritance. But are we as advisors, as lawyers and advisors throughout the process, going to get caught in this quagmire? Because presumably if you're in the process of disinheriting, you are part of the disinheriting process, then there are elements of, well, maybe we're going to get sued for tort, maybe, but maybe damages, maybe exemplary and punitive damages, that somehow we're the ones that stirred the pot when the client came in and started asking these questions. And that's where we come back to our first principles, is that not that there's a dark cloud over us in all scenarios of the disinheritance, but it is more and more complex. And we are getting dragged into these situations where we're becoming witnesses in the proceedings on an unpaid basis, which isn't put into the business model. When we take the will instructions, we're not saying we're going to charge you an extra 25% because we might get dragged into the process. Then we get dragged into the process after death, giving all this evidence and giving our great notes and so on, and lost time and so on that gets dragged into it. So where I'm more and more looking at the disinheritance perspective is how do we manage it a little bit more efficiently, but more how we manage it is in large part understanding the client situation. For example, there's power of attorney disinheritance going on every day. We have clients that will come in and they'll say, you know, my mom wants to give me the house and she's alive and well, and we're going to get dragged into the process of saying, okay, well, Mom, I can't act for Mom, I act for you, so we're mercifully going to pass Mom over down the hall, and Mom's going to see someone else. She's going to come in and, lo and behold, be driven in by the client that you're acting for, and no doubt the lawyer will make sure there's a separate meeting and so on. But the disinheritance or the transfer of this house and so on is being undertaken during life. So we've got this extra layer. We're expected to definitely take good notes when we're acting for the mom. We definitely want to make sure there's no undue influence and ask the same kind of questions we would ask in any will challenge scenario. But we're also going to need to add layers of deeds of gift, maybe add layers of protection to make sure that this disinheritance moment is going to be sustained. The extra layer of getting a capacity assessment at the time, where your client, 9 out of 10 times you wouldn't have done it if you were just taking will instructions. You may not have. In this situation, if you're getting dragged into, you're in a fiduciary arrangement. And, you know, we never can forget that this client has come to see you. If they hold a power of attorney, they are in the fiduciary sphere. So they come to say to you, look, my mom wants to give me more than the other kids, wants to do it now. Well, right off the bat, it's a self-dealing transaction if you are in a fiduciary role. You are an attorney. So whatever you do, the protections are elevated beyond the normal gifting in a will scenario where you just say, look, I'm cutting my kid out, I thought about it, the lawyer takes great notes, and we wrap it up in a nice bow. When I'm holding the power of attorney for my mom and I want to cut my other 4 kids out because my mom told me, of course, it was not coming from me, my mom wants to give me the house, I'm a fiduciary and I'm receiving a gift in that world. And so we've added that extra layer, and it seems to me anyway, we need to add that extra layer of protection in the process. So we separate the instructions, we separate the counsel clearly and identifiably, and make sure that we add on the layer of the capacity assessments and so on. So even in a power of attorney scenario where there's a disinheritance, there's a mechanism of the process that we have to, what I will typically do is refine, and that is, from my perspective, I'm acting for the client, of course, I'm not going to step into the fray, but we also want to get a strong solicitor who will be able to pull together that file, because when Mom dies, or before she dies, maybe she's incapable or whatever, and the lawsuit begins, and people are saying, why is the house no longer in Mom's name? I've got a backdrop of a strong file behind me with a good assessment, and addressing this fundamental problem that the allegation will be made that I can't even receive the gift because I'm in a fiduciary relationship with my mom, and that's a self-dealing transaction, allegedly. So that's a disinheritance in the power of attorney sense. Another good reason, there's non-monetary reasons to disinherit, and I use the illustration when I use disinherit, I use that as a broad term, but let's use an easy example. When we ask our clients, they come in and say, you know, I really have enjoyed the benefits of this particular charitable institution. They've helped me and my family out for all my life, and they say, I want to give something to the charity in the will. and they give a residuary gift. Well, are we asking the next question? Because in our disinheritance world, that means the charities get to look at everything, and they get to see what the residual amount is. Why is the residual amount not $200 and it's only $100? We're into a whole new accounting level. Is it a different question to be asking those clients in those scenarios, or not just a charity, a nephew or a niece, that you say, okay, well, wait a minute, is it giving them 2 points of the 2% of the residue a good idea, or is it better to fix that gift? Because then we've opened ourselves up to a whole series of questions and inquiries that the client may not, A, have thought about, B, we're into a tremendous amount of new costs potentially because of the nature of the inquiry, the rights of the beneficiary to drill down on an accounting basis. And so it may be a good reason to disinherit, in a sense, the specific residual gift and have our clients think through to make a specific gift. Again, it's all fact and case-by-case based, but too often the second question isn't asked when the first question is when the first instructions are given, and that is, I want to have someone enjoy some of my estate, and then they just fall into a residuary status where maybe that's not the right way to do it, and maybe you don't want your nephew to, and if it's an operating company, you don't want your nephew to have to be part of getting the financial statements of the operating company, fighting over whether the retained earnings should be part of residue, and all of those kind of deeper drilling down accounting questions that are proper for a residuary beneficiary to ask. The judge is going to let them ask it, and it's going to add a whole layer on the administration of the estate and the distribution of the estate, and where it could have been very focused, and the same result would have been there, and that is if you quantified X dollars you wanted to give to that individual, you could have done so specifically. Two other specific tools that we use a great deal, of course, are the no contest clauses, or the in terrorem clauses. And then another tool that I put in my paper as well is this agreement not to sue. I want to just spend the last few minutes and then touch on that a little bit. The no contest clauses they're fascinating, and again, they fall well within our business model. We love to see them, and we want you to encourage using them, because it either scares the heck out of you, or it is, let's run through it like a truck. And the nice thing is that if it's drafted well, and well, I say, if it's drafted, we've given some precedents, not that this is the final answer, but if it's drafted thoughtfully in the context of your client's instructions, these things are very powerful tools. And they can be an immediate stop, if not very close to immediate stop. There was back in the, again, in probably the mid-2000s, there's a series of cases that, this is, I've done a bunch of research through the UK analysis and so on, but there is some Canadian authorities for this. But what I've tried to do is sort of summarize the context of no contest clauses. The idea that and really that when it came down to it, one of the cases actually was an interesting one, was they looked at a no contest clause in a discretionary trust. So you got a series of beneficiaries who don't have vested interests, and they're named beneficiaries in a discretionary trust, and a no contest clause. In that case, the clause was very well drafted, and it was easily identified. Whatever it says here, I think the language was, whoever contests the validity of this deed and the trust created, same, we could put in the words will there, it doesn't matter, under it, of the provisions of any conveyance of property by any person or persons of the trustees, and so on and so forth, that person shall cease to become a beneficiary under any of the trusts, and they are not to receive any benefit therefrom. So standard no contest clause, really interesting to do it in the context of a discretionary trust, because of course the beneficiary standing to challenge it is hard when you're not even sure you're going to receive, because or you have received but you may not continue to receive. But anyway, I don't want to get too deep into that. That's maybe only interesting to 3 people in the world that it was put in the context of a discretionary trust. But what it did do was it reminded me that the balancing act the courts are going to say is they're not going to let a clause be too powerful so that it controls the court itself. What the court will allow it to do is the trustees have to still be controlled by the court. So if the clause is so broad that essentially exonerates any and all aspects of the court's role in the process, they typically get pretty grumpy with it. So the clauses that are drawn, and I just recited that, it's not rocket science in the sense that as long as it's clear, the kind of language we're using here is the kind of clauses that have been time and time again seen by the courts as effective planning tools to prevent challenges to the trust document in that case, but to a will. And the final point is, it's just there's a precedent again for what it's worth in the paper. This idea of we can play off our parents a little bit too. If they want to play games with us and one day I'm the favorite and the next day my sister's the favorite, all of those in the family sit down quietly in a room and say, you know what, we're going to let Dad and Mom play this game until they die. Let's sign an agreement right now that says last person standing, we're all going to split it equally. And the agreement says exactly that. Now, it doesn't solve all our problems, but of course, if Mom or Dad want to give it all to charity, we're going to have our own issues. But if they do this game playing of toying and holding off, and we see it all the time with our clients, we see it with the wealthy families do it, the not wealthy families in the sense do it, is if they're going to play that game off one kid over the other for periods of time, then sometimes sitting down, taking that pressure off internally with all of the kids is an effective tool, and so we've just put in an agreement there that as well allows for managing the disinheritance. So I think that's, haven't had time to get into the really esoteric tort law claims that can be made against this, but I do think there's lots of ways to manage disinheritance when we understand better where the tensions in the clients are coming and where we are seeing the trends in terms of the gifting patterns of clients, especially where we're coming into this baby boom generation, passing down the significant wealth. So those are my thoughts. Thank you again for coming to our first day, and we're going to stick around for questions. We can do it some formally or informally, however people want to work the questioning. But thanks very much, and Happy New Year to everyone. All right, doesn't look like there's too many questions, so we can do it informally. We'll stick around at the table here. If you want to have some questions, feel free to pop up and ask, and otherwise we'll all go back and start our days. Thanks again for everything.